ye me mamu nyina akwa abade ba Kantona TV so se ne Kantona TV ya hye mo bossa be na be nyina nsem bi ya edika na editi no Kantona TV ye mama so nsi ebeba wura nsem ne de nsem abeto nipa sa pepe ne ye no na afutuo na akwama amanyofo eche politician ni nyane se eya na omo de mo ho eberawura ahinsensen mu eba ne sanso a emwa mama ne nkɔ nanim sanse politicians ankasa omba abeto ahimfo ma emu nti wo se omdi ebuo ni die bia de ma enananam ahimfo se ne be ya nsem bi nso ba ombetimi ehu kwan a befa so ombetimi akansa se wo ye politician a wo se wudu le mu se wo ye amanyon sem na woma woni edio no achi omde nsem nyina etotudwa ewo nkrampoponi mantem abra Ga Paramount Stool friends and trofo nomne nsem nyina edeto ye nem na emrampan na emrampani for ekasa na say nomle to nsentwefo anim.
This press conference by the Ga Paramount Stool Dzase being held today, 23rd of November 2021, on the ruling of the fast-track High Court at Kumasi. Friends of the media, good morning again. Let me take this opportunity to thank God for giving us the victory for Gadangme, victory for democracy, victory for rule of law and chieftaincy and the chieftaincy institution. The Dzase of the Ga Paramount Stool, led by my good self, invited you to a similar press conference at which we expressed our disgust and surprise at the National House of Chiefs for entering the name of Ga Mantse into the National Register of Chiefs as Ga Mantse. That is the Paramount Chief of Ga Mantse. When there was a case in the nature of Mantemus pending at the High Court in Kumasi against the National House of Chiefs for removing the name of Adama Latse II, the substantive Ga Mantse from the Register of Chiefs on 1st April 2021. In addition to 3 other cases pending before the National House of Chiefs, Greater Accra Regional House of Chiefs, and the High Court in Tema, respectively. Ladies and gentlemen of the media, the purpose of inviting you this morning is to brief you on the outcome of the ruling of the fast-track High Court sitting in Kumasi on the 11th day of November 2021, presided over by the Justice of the High Court. A ruling delivered by the learned judge on the 28th July 2021 determined the issue of jurisdiction over the instant application and ruled that he has jurisdiction and accordingly assumed jurisdiction in the present ruling. His Lordship was emphatic that the instant application by Boni Nietaki Adama Latse II, the Ga Mantse, has merits and accordingly granted it based on the following facts. 1. The conduct of the highly respected institution like the National House of Chiefs in the absence of an order of a court of competent jurisdiction ordering the expulsion of Nietaki Adama Latse's name from the National Register of Chiefs, coupled with an existing ruling of the High Court, Kumasi, which dismissed an application in the nature of mandamus for the deletion of the name of Nietaki Adama Latse from the Register of Chiefs, leaves much to be desired and ought not to be repeated. And I want to emphasize this. The act of removing the Adama Latse's name from the register by the National House of Chiefs when there was a mandamus case against Kentucky and the National House of Chiefs, and they're going ahead to delete his name and replacing it with Kentucky, leaves much to be desired and ought not to be repeated. 2. Nintaki Adama Latse's right to be heard is basic, fundamental, and failure to adhere to same by the National House of Chiefs will obviously be fatal to their case. In the instant case, nowhere was Nintaki Adama Latse notified by the National House of Chiefs regarding the processes that the National Register of Chiefs went through, leading to the expulsion of the name of Taki Adama Latse from the National Register of Chiefs. Neither for his comments, indeed, from the affidavit in evidence, the Justice of the High Court was of the considered view that the entire proceedings at the National House of Chiefs plenary, if any, was conducted on the blind side of Nintaki Adama Latse. It must be added that the ruling the National House of Chiefs relied on did not also order the expunging of the name of Nintaki Adama Latse, that, interestingly enough, the National House of Chiefs failed to exhibit minutes of the plenary indicating that a meeting was held. Members present at the said plenary and the decision itself were not attached as exhibits. What was exhibited was a letter indicating that a meeting of the plenary took place and its outcome was the decision to expand the name of Nintaki Adama Latse II from the Register of Chiefs. Having read the affidavit evidence on record, it is safe to say that the acts of the National House of Chiefs and its register breach the rules of natural justice, thereby rendering their proceedings leading to the decision to expunge the name of Nintaki Adama Latse from the Register of Chiefs a nullity. 3. Having regard to the above discussion of the law coupled with the affidavit evidence together with the exhibit, Nintaki Adama Latse has sufficiently made a case to warrant the grant of instant application. Further, in coming to the above stated conclusion, the Justice of the High Court weighed the equities in the case, hence his decision to exercise the court's discretion in favor of granting the instant application. Indeed, the Justice of the High Court was of the opinion and considered view that there was no other alternative remedy available to Nintaki Adama Latse than the instant application in the circumstance. The instant application has merit and it is accordingly granted. The Justice of the High Court hereby orders the restoration of the name of the applicant, Nintaki Adama Latse II, into the Register of Chiefs at the National House of Chiefs by the National House of Chiefs and its registrar within 14 days from the day of the ruling. For the avoidance of doubt, on or before 25th November 2021, a cost of 25,000 was awarded against the National House of Chiefs in line with the order 74 of C1/47. So they have tomorrow and the next day to abide by the judicial ruling. Friends of the media, clearly the Ga Paramount Stool has been vindicated by their earlier position that the National House of Chiefs acted against the rule of law and natural justice. The National House of Chiefs refused to listen to the side of Boni, Niitaki Adama Latse, an inviolable principle of natural justice. That is, odi alteram partem, against the principles of justice and fairness. Again, the principles of justice and fairness dictate that until his position is successfully challenged in court, he remains the substantive Ga Mantse, but the National House of Chiefs violated that principle. Although Council of Niitaki Adama Latse made legal requests for the right thing to be done, all these were ignored by the National House of Chiefs and rather went ahead to expunge his name when an existing ruling of the High Court delivered by His Lordship C.A. Wilson, dated 21st May 2016, dismissing a request by Niitete to have the name of Niitaki Adama Latse deleted from the Chiefs list failed, and the cost of 20,000 awarded against Niitete in that application. I'm to confirm that Tetekwe has up to now not paid that fine.
Edamu nyina mo ase se magye mbra hwe Kantona TV e kan die wo.